had been waiting for the right time to tell them. That's the first thing I want you to understand about the morning I walked into HR, because the right time is something you think exists when you are pregnant at a job you have worked for 3 years, a job you are good at, a job you genuinely believed saw you as a person and not a liability. I had been waiting for the end of the quarter. I had been waiting to be past the first trimester. I had been waiting until I felt stable enough to have the conversation without it feeling like a confession. I told my manager on a Friday. I told HR the following Monday. I was 12 weeks, 2 days. The baby was healthy. I had prepared a brief maternity leave plan, showing how my projects could be covered, demonstrating that I had thought through the operational gap. I had been a project manager for 3 years. I knew how to plan. I thought planning would protect me. On Thursday of that same week, my manager put a performance improvement plan on my calendar. I want to be precise about the timeline because the timing is the evidence. The PHYPE had been generated. It had a file date visible in the document properties when I later requested a copy through my attorney. That file date was Monday, the same day I spoke with HR. The document was written the day I disclosed my pregnancy. The meeting where it was presented to me was scheduled for Thursday. There were 4 days between the disclosure and the plan. The plan cited concerns that in my 3 years of annual reviews, all satisfactory or above, had never been mentioned. The concerns were communication style, time management, stakeholder alignment. These are the kinds of performance concerns that are difficult to contest because they are vague enough to describe almost anyone and specific enough to seem like they describe a particular person. They are also, I would later learn from the attorney I hired, the most commonly cited concerns in pregnancy discrimination cases, not because they are specifically chosen for that purpose in every case, but because they are plausible deniability in a form that human resources departments have refined over decades. I did not sign the PEP. My attorney advised against it. Instead, I filed an internal complaint with HR documenting the timeline, the Friday disclosure, the Monday meeting, the Monday file date on the plan. HR opened an investigation. The investigation was conducted by the same HR department I had disclosed my pregnancy to on Monday. The finding was that there was no evidence of discriminatory intent, and that the performance plan had been in development prior to my disclosure. The document had a Monday file date. I filed with the Equal Employment Opportunity Commission 6 weeks later, after it became clear that continuing at the company was not viable. The EEOC process is slow by design. Their median processing time for pregnancy discrimination complaints is approximately 10 months, though many cases stretch to 2 years or longer. During that window, you are expected to continue working in the same environment where you made the complaint, or to leave and risk being classified as having voluntarily resigned. I was placed on a managed exit timeline that the company described as a mutual separation. My attorney described it differently. The baby was born in October. I was no longer employed by the time she arrived. I was on COBRA health insurance, which cost more per month than my mortgage. I was applying for jobs in the last trimester of my pregnancy with a performance improvement plan in my file history and a pending EEOC complaint that I was legally required to disclose in some hiring situations. The EEOC issued a right to sue letter 14 months after I filed. My attorney filed suit. The case settled before trial. I signed a confidentiality agreement as a condition of the settlement, so I cannot tell you the amount or the terms. What I can tell you is that settling before trial is not a vindication. It is the company deciding that the cost of settlement is lower than the cost of discovery. Discovery is where the emails live. Discovery is where you find out whether the conversation about the PEP happened before or after my disclosure, whether it was written before or after, whether my name appeared in a conversation in that period that I was not part of. The company decided not to let discovery happen. That decision is also evidence of something. My daughter is 2 now. I went back to work. Different company, different industry, different title. I did not put the PEP on my resume. I did not mention the EEOC complaint in interviews. I described my gap as maternity leave, which was technically accurate for the last few months of it. The rest of the gap I described as a consulting period, which was technically accurate for the first few months of it. I managed the narrative the way you manage any project when the underlying facts are complicated. I told the true story at the scale where it was legible. The thing I think about most is not the PIP, not the Monday file date. It is the moment I spent waiting for the right time to disclose. The calculation I made about safety and timing, and whether I was far enough along, whether the company was stable enough, whether my standing was secure enough, the care I put into being a good faith employee who planned ahead and showed up prepared. The Pregnancy Discrimination Act has been federal law since 1978. It prohibits termination, demotion, and adverse action based on pregnancy. The enforcement mechanism is the EEOC complaint process, which takes a median of 10 months, costs attorney fees most women cannot absorb, requires you to continue in a hostile environment during the investigation, and results in a confidential settlement in the majority of cases that resolve before trial, which means the company does not have to acknowledge anything, and the employee cannot discuss the outcome. There are approximately 2,500 pregnancy discrimination charges filed with the EEOC each year. That number has not substantially decreased since the act was passed. I told my daughter, when she was old enough to understand the general shape of it, that I got a new job before she was born because the old job wasn't right. That is also technically accurate. When she is older, I will tell her the rest of it. I will tell her about the timing. I will tell her about the Monday file date. I will tell her about the 10 months, and the COBRA, and the managed exit. I will tell her because she will eventually be at a job, and the right time to tell her is now rather than when she needs it. The law was supposed to protect me. The process that enforces the law was designed in a way that made protection cost more than most women can pay. Is that still the law's failure, or has it become the system operating exactly as intended?